So you got your estate plan set up and your trust is written and your will is written and all your advanced healthcare directives and powers of attorney are written. Now, where do you actually keep this stuff? In this video, I'm going to tell you first a couple bad places to keep things, and then I'm going to tell you the best places to keep things, including where I keep my own estate plan. My name is Michael Pevney. I am an estate planning lawyer. I create estate plans for California families. I only practice in California, but if you're not in California, some of this information may be very relevant to you as well. And please follow this page and subscribe if you are interested in estate planning and more estate planning information. I've got many hundreds of videos out there and a lot of viewers across many different platforms. If you have a question about estate planning, please ask it in the comments. I am oftentimes able to respond. So let's talk about first why it's important to properly store our estate plan. It goes without saying that these are essential documents. Oftentimes for my clients, the sort of centralized document that I create for them is a trust, a living trust. There's always going to be some sort of a will, a power of attorney document, an advanced healthcare directive, maybe even a document naming who we want to be the guardian for our younger children if necessary, and then our final instructions. What do we want to happen to our body when we are gone? So first, I want to go through a couple of bad places, in my opinion, to store an estate plan. First, a bank safe deposit box. Let's keep the estate plan out of a bank safe deposit box. Here's why. When it's game time, when these documents are necessary, we don't want there to be too many barriers in order to access them. So first, in order to access them, someone might need to be a signer on an account, but it's not necessarily like having a joint bank account. A bank safe deposit box is very much like almost leasing a small piece of space. And if somebody doesn't have access to those documents, oftentimes, well, if you're not a signer on the account, or you're do not have access to that bank safe deposit box, the bank has pretty hard lines on these sort of things, and they're not going to let you in there. And they're not going to let you in there oftentimes unless you have a court order. That can be very difficult. It's going to cause unnecessary delays, especially if this is a, as I said, game time situation. Somebody is in the hospital, somebody is in a coma, and they have an advanced health care directive. And we don't know where this stuff is going to, what's supposed to happen to them unless we have this actual document itself. First, you got to rely on if the bank's even going to be open or not. People talk about bankers' hours because there's a lot of bank holidays and they close at 5 o'clock or 6 o'clock, and they don't open, they're closed on Sunday, and they don't open until noon. They're only open for 4 hours on Saturday. You don't want to have to rely on that at all. Another bad place to keep your estate planning documents is your lawyer. Do not make your lawyer responsible for keeping the originals. I do not maintain original documents for any of my clients. There'd be hundreds of thousands of pages of documents that I am responsible for that I need to get to you. What if I want to take a vacation and the office is going to be locked and it's not going to be staffed, right? Maybe under circumstances, certain circumstances, a lawyer can store original documents, but for the most part, in my practice, I send the originals home with my clients. But that doesn't mean that I don't know what these documents say. So where do you keep all of this stuff? So no secret here. I keep my documents, my estate planning documents, in the closet. It's on the top shelf in the bedroom closet. We want them to be accessible. Now, there's a balance between accessibility and privacy. Now, estate planning documents, at least while you're alive, they are private documents, especially a trust. They're not filed with any government agency. So it's essentially on you to make sure that these documents are both kept safe and kept accessible. So we can keep things in a safe place that's more difficult to access. And in that case, we need to make sure that the people that need access when it comes time, when you pass away or you're incapacitated, they know how to get in there. Now, mine are sort of hidden in plain sight, so to speak, and the people that need to know where they are know where the originals are. What I do for my clients, I choose to keep account numbers off of the actual documents themselves. I also don't include social security numbers in the documents that I create for my clients. I like to tell people, if you get your bag stolen or your phone stolen or your wallet stolen, you're very likely at a much higher risk of identity theft than you were if your estate planning documents were stolen. And that's not to say that these aren't private documents or that these aren't personal documents. They are. But if you want to be a little bit safer than that, you can, of course, get a safe, fireproof safe with however many minutes of fireproof rating, that sort of thing. But in that situation, the people that are essential to your estate plan need to have access. They need to have the key, the code, the combination. With their handprint needs to be able to be one of the accessible fingerprints or handprints or eye scans or whatever we're using these days to have safes be accessible. So this gives us a balance between some safety from strangers and accessibility to the people that we want to know. Now, what about copies? How about copies of things? Now, I know I said I don't keep and maintain the original documents for my clients, but what I do when we sign documents, come by my office, we sign everything, we get everything notarized, and as you're doing your fingerprints in the notary book, we are scanning everything. And so I maintain an original copy, an original digital copy of everything. And so that's going to be accessible. I'm going to know what everything says. I always send a digital copy. It's just basically a long PDF file after everything's signed, after everything has been notarized, to my clients. After we say goodbye to them, send them with their nice little folder with all of the originals in them. And then I instruct my clients to make sure that the other people that are important to that trust, the next trustee, the person that's going to be the power of attorney, the kids, if necessary, that they have their own digital copy of this plan so that we know what it actually says. Oftentimes, a digital copy can stand in place of the actual original physical papers and physical documents. It depends a little bit. Oftentimes, it's banks that want to see originals. Oftentimes, they don't. Oftentimes, you just need to sign an affidavit that says this is what the document says, that sort of thing. And when it comes to real estate transfers, that sort of thing, if a county needs to see something, in my experience, oftentimes a copy can just be emailed. A digital copy can oftentimes be emailed, or we show them in that way. So accessibility is important. The lawyer, me as a lawyer, is always going to maintain a digital copy of things, but you are going to keep the originals. At least that's the way that I run my practice. And we're going to want to make sure that the people that are essential to your plan know where these originals are, because there are some nightmare worst case scenarios out there. Like, everybody knows that there is an estate plan, that it exists, but we can't find it. The lawyer doesn't have a copy, digital or otherwise, of it. The parents didn't tell anybody where everything was being kept. And so there's no actual document, even though we pretty much know where things we want it to go. It's nobody's going to be able to honor anything unless we can actually show the bank a document or file something in court. And what's often going to happen is things are going to have to unnecessarily go through probate, which is costly, it's stressful, it's time consuming, and things may not end up going to the people and the places where the people that originally created that estate plan are. So we want to avoid that by keeping things accessible to the people that need to have them at the time that they need to have them. So just to sum up here, when we set up that estate plan and we create everything and we sign everything, we notarize everything, in my opinion, everything goes home with the people that created the estate plan. The originals go home with them. They need to be accessible, whether that is locked up in a safe or not. And if it is locked up in a safe, the important people, the next trustee, the executor, needs to have access to them. A bank safe deposit box is a bad place to keep things. The lawyer's office is a bad place to keep originals. What if the lawyer wants to go on vacation? What about when the lawyer sells their practice? What about when the lawyer dies? I'm not taking that kind of responsibility for other people's stuff. There's a lot of liability issues going on there as well. And lawyers are very careful about that sort of thing. So we always want to make sure that there are enough copies and accessibility, digital copies, given to the people that need them. So hopefully that answers that question about what do we do with these estate planning documents after we've created that estate plan? So if you have any questions about estate planning and you live in California and you haven't set up that estate plan set up, you can always set up a time to meet with me and my firm for free. Gotta live in California by going to my website, ocestateplanlawyer.com. There should be links and other information in the description of this video. Please subscribe to me for more estate planning information and appreciate your time and your attention. Thanks.